Hi, and welcome back, Attorney Steve Vondran. Happy Friday to you here, and welcome back to another exciting episode of Litigation Warrior. Okay, so I had a question. This is a quick one for a Friday. I had a question. I'm filing motions in the Central District of California. What's that look like? What do I need to know? What are the basics? Well, this is general legal information only and certainly not legal advice. You're going to have to go do your own work and make sure that you know what you're doing. But I'm going to give you just some general pointers, having been in the Central District many times. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, here we are. So as you can see up here, I have a little information about California's Central District motions. And let's just get right into it. So first thing you want to do, you have a motion you want to file. Let's just say it's a motion to dismiss a case. Somebody files a lawsuit. You go, this is total trash. I'm filing a motion to dismiss Rule 12B under the federal rules. So what you're looking at, you got to get yourself a hearing date. Sometimes you got to check the court's calendar, check with the clerk, see what dates are available. You need to calendar it out enough time to give notice to the other party. Usually I like to just calendar it out about 40 days is usually what I look at. Boom. Then you're going to file your notice of motion. Your notice is basically just giving a short, concise, plain statement of the relief that you seek. For example, if you're filing a motion to dismiss, defendant seeks to dismiss the motion on the grounds that plaintiff failed to plead a plausible cause of action, okay, something like that, or lacks jurisdiction or something, let's say. So a short and plain statement of what you're looking for, notice of the time, date, and the hearing that you've already received, and of course the motion itself, this is what you're asking the court to do. And this is very simple. You're going to put the date and the time of the hearing. That's pretty typical. The name of the judicial officer, the judge or the magistrate judge, your memorandum of points and authorities. This is your cases, okay? And if you exceed a certain number of pages, usually it's 10. That's a general rule that I go by. You need to put your table of authorities, table of contents. Table of authorities is all your cases, your case law, and your table of contents is basically the outline of your motion, okay? So you're going to put your points and authorities. You want to get those good cases weaved in there. You want your background facts. You want to tell the judge what's going on, and you want to weave that good binding persuasive case law in there. And then any evidence you have to support your motion. This could be what we call request for judicial notice. That's a topic of another video. But basically things that are so obvious and well known, it's beyond dispute. The earth is round, for example, okay? And any declarations. Now, a declaration, I haven't done a video on this. I'm going to be doing one shortly on declarations. I need to do that. But a declaration is basically a sworn statement by someone who has personal knowledge of certain facts relevant to the case. They're swearing under declaration under penalty of perjury that the foregoing is true. Now, you want to limit that to facts and not opinions. A lot of times people will start rambling and, start rambling all over the place. I don't think most judges want to hear that. It's the facts. I saw the plane touch down and hit the ground. I saw the wheel come off. I saw the plane burst into a ball of smoke. Those kinds of factual things, okay? So that's evidence, documents, photos, things that could be authenticated. Somebody authenticates them, say they're real, they are what they purport to be. Declarations from other people, those kinds of things. That's your notice of motion. That's the beef. That's the bulk of your motion, okay? So you want to make sure this looks really good. Again, then you file it and serve it on all parties. We know that. All parties are entitled to copy that, see what's going on. And let me move over here. So a big question I get is, well, how many days, Attorney Steve? How many days do I get to respond? I want to respond to that because I have a good complaint. I should not be dismissed. I want to fight this. Okay, well, settle down. I get it. 21 calendar days, because under Rule 6, it talks about if things are mentioned in terms of days, like it does in the local rules of the Central District, you have 21 calendar days. So that means you count Saturday, Sunday, and legal holidays, okay? So I'm not going to get into calendaring. You got to figure this out on your own. I ain't touching that with a 10-foot pole. But this is in general legal information only based on the last time I looked up the rules. Still the same last I checked. If it's a motion for a new trial, then you need to respond in 10 days. A little more urgency there for a new trial, okay? So this is your general time frame. So you book that out. So if the hearing's out here in June or July, then you know you got 21 calendar days before the hearing, 21 calendar days before the hearing to get your opposition in. Your opposition can, of course, include these things as well, okay? So they do that. You can, it's like tennis. They throw it over, you can hit it back, okay? Or if you don't want to oppose the motion, you can simply file a document that says we do not oppose. Of course, it could dismiss your case or so forth and so on. But if you don't oppose, sometimes you don't oppose a motion. You just go, all right, sounds good to me. But again, so that's Rule 6 that you're going to be looking at there. Let me go ahead and check the box here. You know, my viewers know I like to check the boxes. Rule 6, look up your rules so you know what you're filing. The person who filed the motion, called the movant or the moving party, gets to also file a reply. Again, that is not more than 14 days before the hearing. So these are kind of your critical days to be thinking in mind. 21, 14, enough time for valid service of process here so that some of the timing issues involved in this. If you're late, you could be sanctioned. So you don't want to turn this in, 18 days before and have the judge say, didn't you read the local rules here, counsel? Oh, well, no, you could be subject to sanctions. Nobody wants sanctions, right? Personal appearances are normally required on these motions. If there's an emergency, perhaps you can file a motion to, appear by phone or something, but the general rule is personal appearances are required in federal court here. Again, I always say check the judge's rules. I think this is often overlooked. The judges will usually have their own set of rules on top of the local rules. For the district, they'll also have their own set of rules, so you're going to want to be familiar with those and make sure that you're complying with not only the local rules, the F.R.C.P, but also the judge's rules, okay? And by the way, I like to send courtesy copies to the judges, courtesy copies of my motions, okay? 14 point, what does that mean, 14 point? Central District, and like myself, I like the pleadings in 14 font, nice and big where you can read them so you don't have to. The 12 font, as you get older in life, the 12 font starts looking like 9 font and then 6 font and then 3 font and you just can't see it anymore. I guess that's old age for you. But the judges like it in 14 font, so make sure you've got adequate font here. I have here judge's copy. We just talked about that. And what's my last one here? Oh, scannable PDFs. When you're attaching PDFs, so you're putting PDFs, maybe you're adding some motions or you've got attachments and things like that. You want to do it in a searchable PDF. For example, you say you create the document in Word and then save it not as a Word and print it out and then try to scan it. Sometimes that's not searchable, but if you just do the document, save as PDF, I have found many times that is scannable. Otherwise, you get a deficiency notice. That's never fun. You get a deficiency notice that you didn't file something right. Okay, so that's a general overview. Attorney Steve, Federal District Court, Central District of California. And just remember, districts are different. Your local rules are different. Your judges are different. So you've got to look up your own rules in your own jurisdiction. This is not going to apply everywhere. And again, general information only, okay? Just to get your wheels thinking here on a Friday, okay? So hope you like this video. If you do, give me that thumbs up. Don't be so shy. I mean, just give me this, push that little button and go, Attorney Steve, we like your work. Keep it up. It's better than politics. We're getting bored to death of politics. So if you like it, subscribe. I appreciate it. Any comments below? I try to get to all my comments. Please keep it clean. I like a nice, clean channel here. Other than that, have a great weekend. Carpe diem. Seize the weekend. And hope all is well for everyone. We'll see you again. Thanks for watching.